This is a hearing concerning the unemployment insurance claim of Ms. Cynthia James. My name is Claude Simon. I'm a hearing examiner for the Wyoming State Department of Employment. Participating in this hearing is the claimant, Cynthia James. Acting as a witness for the claimant is Ms. Carol Adams. Representing the employer in this matter, Lakeview Nursing Home, will be Ms. Janet Jenkins. All participants in this hearing will be appearing by telephone. We're having a hearing today because the employer has disagreed with a decision made by a deputy of the Department of Employment, which awarded unemployment insurance benefits to Ms. James and charged the employer for any unemployment benefits which might be paid to Ms. James. A set procedure will be followed in this hearing. I will first ask questions of the employer witness, Ms. Jenkins. Following those questions, Ms. James will be provided with the opportunity to ask questions of Ms. Jenkins regarding her testimony. I will then ask questions of the claimant, Ms. James. Following my questions for Ms. James, Ms. Jenkins will be given the opportunity to ask questions of Ms. James. Ms. James, you will be then provided the opportunity to call and question your witness, Carol Adams. Ms. Jenkins will then be provided an opportunity to question Ms. Adams regarding her testimony. Upon completing questioning of all witnesses, both Ms. Jenkins and Ms. James will each be offered an opportunity to add additional information if you have any. After all evidence is taken, you will both be offered an opportunity for closing remarks. Ms. James, do you have any questions concerning procedure?
No.
Ms. Jenkins, do you have any questions concerning procedures?
No.
The scene you have just watched is the beginning of an unemployment insurance appeals hearing, much like the one you're about to experience. This presentation is designed to help you prepare for that hearing. Federal and state laws entitle you to an opportunity for a fair hearing if you disagree with the deputy's decision to grant or deny benefits. A fair hearing means an impartial examiner will decide your case after hearing all testimony and evidence. It is the examiner's job to ensure that you understand the proceedings and have the time you need to present testimony and evidence about your case. There's a lot you can do before your hearing to make sure that you're ready. You must carefully read the hearing notice. This tells you the date, time, and place of your hearing. If you receive a notice of telephone hearing, you must contact the appeals section of the Wyoming Department of Employment to provide a telephone number where you and your witnesses may be contacted for the hearing. Failure to provide those telephone numbers will likely result in a decision which is not in your favor. It is very important that you be on time for the hearing. If you do not show up, you will probably lose. Be sure to bring to the hearing any witnesses or evidence that can help your case, even if the witness or evidence was presented before to the local unemployment insurance office. If you are having a telephone hearing, you must provide the names of your witnesses and a telephone number where they can be contacted for the hearing. You also must provide copies of any documents you would like considered as evidence to the appeals section and to the opposing party. In order to make sure that your hearing is completely independent of the local unemployment office, only evidence presented in the hearing will be considered. This is very important. If any papers, documents, or other evidence was presented to the local unemployment office, you will need to resubmit those documents during the appeals hearing. Also, you must make sure that the opposing side is provided with a copy of any documents you would like considered as evidence. The most important point we can make is to prepare. This hearing will likely be your only opportunity to present testimony and evidence regarding your case. You must make sure that all important evidence is presented during the hearing. Right now, let's return to the hearing you are watching. In this case, the claimant has been fired from her job. Pay close attention to whether or not the parties were properly prepared for this hearing.
Testimony in this hearing will be taken under oath. Will each of you please raise your right hand and prepare to take the oath? Do you swear or affirm that the testimony you are about to provide will be the truth, the whole truth, and nothing but the truth? Ms. Jenkins, do you so affirm?
Yes.
Ms. James, do you so affirm?
Yes, I do.
Ms. Adams, do you so affirm?
I do.
Ms. Jenkins, are you employed by Lakeview Nursing Home?
Yes, I am the personnel director there.
Are you familiar with the employment of Cynthia James?
Yes.
Was Ms. James discharged from employment from Lakeview Nursing Home?
Yes.
Why was Ms. James discharged?
Miss James was abusive towards a patient.
Well, what did Ms. James do that was considered being abusive to a patient?
I have a signed statement here made by Bobby Sales. He is a custodian at the home, stating that he saw Miss James fighting with a patient.
When did this occur?
I don't know for sure, either February 3rd or 4th, 1996. The director of nursing overheard Billy telling a coworker about the incident, and then had Billy write up a statement. Billy wasn't sure what date the incident occurred, but his written statement is dated February 8th, 1996. I'd like this statement entered as evidence.
Was this written statement considered in your decision to terminate Ms. James' employment?
Yes, Mr. Sales' statement was the reason for termination.
Did you provide a copy of this statement to Ms. James prior to this hearing?
Yes, I did.
Ms. James, do you have a copy of the February 8, 1996 statement from Bobby Sales?
Yes, I do.
Do you have an objection to this statement being considered as evidence?
Yes, the statement is not true. I was not fighting with the patient. Also, the statement is hearsay, and Mr. Sales is not here to ask why he wrote the statement. I mean, I'm not even sure why he wrote it.
I will overrule that objection. Hearsay testimony is admissible in this hearing. Because the statement was critical to the employer's decision to terminate, it is relevant to the hearing today. The document is marked as Employer's Exhibit Number 1 and entered into the record. Ms. James, you will later be given an opportunity to tell your side of the story and to refute this document. Ms. Jenkins, what action did the employer take after receiving the statement from Bobby Sales?
Well, we talked with Miss James. She told us that the patient became combative when Miss James tried to give medicine to the patient, and Miss James was trying to hold the patient's arms so that the patient could not strike her.
What did the employer do after talking to Miss James?
We cannot have employees who are abusive to patients, so we terminated Miss James' employment.
Do you have anything else to add?
No.
Ms. James, do you have any questions for Ms. Jenkins regarding her testimony?
Yes, I do.
Please proceed with your questions.
Ms. Jenkins, during our discussion about this incident, do you ever remember me telling you that there was someone else present in the room who saw the entire incident?
Yes.
Did you question this individual?
No.
And why not?
We already had a written statement and did not feel it was necessary.
I have no further questions.
Ms. James, were you employed by Lakeview Nursing Home?
Yes.
Were you discharged from your employment there?
Yes, I was.
Why were you discharged?
They said I was fighting with the patient, but I wasn't. I was just trying to give the patient his medications, and he started trying to hit me. So I grabbed his arms and tried to stop him from hitting me.
What happened next?
Well, the patient eventually calmed down and took his medications. After that, I completed my rounds, and I didn't hear anything more about this for about 1 week.
Did the employer talk to you about this incident?
Yes. On February 10th, 1996, I was called to a meeting with Ms. Jenkins about what happened, and I told her just what I've said here today. I also told her that Carol Adams was in the patient's room with me and saw the whole thing. Carol Adams is a nurse's aide there. Ms. Jenkins told me she didn't care and that I was being fired because someone saw me fighting with a patient.
Do you have anything else to add?
Yes, I have Carol Adams here as a witness.
We will question Ms. Adams later. Ms. Jenkins, do you have questions for Ms. James regarding her testimony?
No.
Ms. James, would you like to question your witness, Carol Adams, at this time?
Yes. Carol, were you working with me on February 4th, 1996?
Yes, I had just been hired and you were training me.
Did we have any problems with any patients at that time?
Yes, we were trying to give care to a male patient. He was resisting the care. You offered him his medication and he swung his arms at you, knocking the medication to the floor. It looked like he was trying to hit you. After that, we left his room for a short while, hoping he would calm down. About 10 minutes later, we returned with some fresh medication. The patient again swung his arms at you. You grabbed his arms and held them down.
Do you feel I was being abusive to the patient?
No, I think you were just protecting yourself and me.
I have no further questions.
Ms. Jenkins, do you have any questions for this witness?
No.
Ms. Jenkins, do you have anything else to add?
No.
Ms. James, do you have anything else to add?
No, I don't.
This is a case of poor preparation on the part of the employer and good preparation by the claimant. The employer should have brought the custodian, Billy Sales, who witnessed the incident in question. The written statement of Mr. Sales was hearsay evidence and probably would not be given the same weight as the direct sworn testimony of someone who witnessed the events. The claimant was prepared for the hearing and had a credible witness that saw the events in question.
As you could see, the hearing is carefully controlled by the examiner. This is done to ensure that each person has the same chance to present their case. Here are a few more important points. Once the Department of Employment receives your request for a hearing, an appeals hearing will be promptly scheduled. Again, read the hearing notice carefully. If you are scheduled for a telephone hearing, you must provide a telephone number where you can be contacted for the hearing. Do not assume that someone will look up your telephone number to call you. Failure to provide a telephone number could result in you not being included in the hearing. An information pamphlet is mailed along with the hearing notice. Like this video, the pamphlet is designed to help you prepare for the hearing. If you have an emergency and cannot participate in the hearings as scheduled, immediately contact the appeals section of the Department of Employment to request rescheduling. Hearings will be rescheduled only in compelling circumstances. A telephone number for contacting the appeals section is included on the hearing notice. If you need an interpreter or have other special needs, immediately contact the appeals section by telephoning the number provided on the notice. Arrangements will be made to accommodate your needs. You may be represented by a lawyer if you choose. However, you will be given equal treatment whether or not you hire an attorney. If you do hire an attorney, you will be responsible for paying any fee charged by that attorney. If you ask someone to appear as a witness and they refuse, you can have that person subpoenaed. This means they will be compelled by law to appear. You may also have a subpoena issued to produce written documents or other evidence that you cannot obtain on your own. Before any subpoena will be issued, you must first attempt to arrange for the witness or obtain the documents on your own. Let's look at another hearing. Again, ask yourself if the parties seem prepared.
This is a hearing in the case of Ms. Claire Chrisman. My name is Arthur Johnson. I am the Administrative Hearing Officer with the Wyoming Department of Employment. I am here to hear and decide this case. Present at today's hearing are Ms. Chrisman, the claimant, and Mr. Sam Everett, co-owner of Emily's Cafe. We are here today because the employer, Emily's Cafe, appealed the decision of the local unemployment office to award benefits to Ms. Chrisman. I will issue a new decision in this case, and I will base my decision on the evidence presented in today's hearing. I am not bound to honor the decision of the local unemployment office. As you can see, this hearing is being tape recorded. Witnesses will take an oath to tell the truth, and if you have any documents that you want considered, each document will be marked as evidence before being considered. Now, as for how this hearing works, basically all testimony is taken by questions and answers. I'll ask each of you questions, and when I finish, each of you will have a chance to ask the other questions. Now, is there anything about this procedure which you don't understand?
When do I get asked questions?
I'll help you keep track of when it's your time to ask or answer any questions. Will you raise your right hand? Do you swear or affirm that the testimony you are about to give is the truth to the best of your belief and knowledge?
Yes.
When did you work at Emily's Cafe?
Until June 5th, about 6 months.
You were a waitress?
Yes.
And what were your hours?
I worked 6 a.m. to 2 p.m. Monday through Friday.
And who was responsible for scheduling your hours?
Emily, my boss, she would put the schedule up on Fridays before the weekend, but I worked the same schedule.
When was the next time you were scheduled to work after June 5th?
I never was. Emily took my name off the schedule. Like I said, I worked pretty regular hours, so I didn't check the schedule unless I knew there was going to be a change. So I got a call on Saturday night from Helen. She's another waitress there. And she told me that my name wasn't on the schedule. She told me that Emily said she wasn't going to schedule me anymore. So I tried to get a hold of Emily, but she was in Boston, so I went down and checked it out myself, and I wasn't on the schedule. So Monday, I went down and filed for unemployment.
Why didn't you ask Helen to come here and testify?
Helen? Why would I? She would say the same thing I just did. I didn't think it was necessary. Besides, she still works there. And coming down here to get into an argument with her boss, I didn't think she'd do it.
Okay. Is there anything else?
No.
Mr. Everett, do you have any questions of Miss Chrisman?
She's wrong. Emily never said she was fired.
Mr. Everett, this is your opportunity to ask questions.
Okay, did Emily ever say you were fired?
No. No.
Okay, didn't you tell Helen that you were going to quit anyway because it was too hard to work and too hard to take care of your son?
No. I've complained about how hard it is to work and raise a child, but I never said I was going to quit. Don't go trying to lay this on me.
What are you talking about?
You know exactly what I'm talking about.
Ms. Chrisman, Mr. Everett, we're just here to gather the facts, not have an argument. Now, if you have no other questions of Ms. Chrisman, Mr. Everett, I think we can go ahead with your testimony.
No, I have no further questions, but I don't care what she said. She quit. I did not fire her.
Mr. Everett, you'll have all the time you need to tell your story, but first I must swear you in. Will you please raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth to the best of your knowledge and belief?
Yes.
What is your position with Emily's Cafe?
I am the general manager and co-owner, along with Emily, my wife.
And who's responsible for making the schedule for the waitresses?
Emily.
Was Miss Chrisman scheduled to work the week of Monday, June 7th?
Well, she would have been if she'd called or come in on the 7th instead of filing for unemployment. Emily did take her off for a week just so she would set up and take notice. I mean, she was coming in late, she was leaving early way too often. We were fed up, but Emily never fired her and never said that to Helen.
Why isn't Emily here to testify as to what she told Helen?
It's 9 in the morning, we're busy, it was easier for me to come.
Yes, but she's the one who had the conversation, so her testimony would be more reliable. She was there. Okay, is there anything else?
No, that's it. We just wanted her to pay attention, come in on time, you know.
Ms. Chrisman, any questions?
Why didn't you just call and tell me I was off the schedule?
We figured you'd come in at a regular time on Monday and we would discuss it. I think you're more interested in drawing unemployment than keeping your job.
That's not true.
If you have no other questions, Ms. Chrisman, now that you've heard Mr. Everett's testimony, do you have anything else to add?
Like I said, they were just looking for a way to get rid of some people.
That's a lie. We laid off one waitress and that's it.
Mr. Everett, Ms. Chrisman, do either of you have anything new to add?
No, I guess not.
No.
Okay, that being the case, this hearing is officially closed. Based on the evidence presented in this hearing, I will be making a decision in writing, which both of you will receive in the mail. I thank you for your participation. This is a case of poor preparation on the part of both these people. Ms. Chrisman could and should have brought Helen here to testify that she heard Emily say she was fed up with Chrisman and wasn't going to schedule her anymore. And Mr. Everett perhaps should have stayed at the cafe and sent Emily, since she had more direct knowledge of this case. It's important to think these things through. Both these people were relying on what someone else had told them. Ms. Chrisman heard from Helen. Mr. Everett heard from his wife. That's called hearsay, and it's admissible as evidence, but it's not as reliable as information from somebody who directly witnessed the events.
You have just seen examples of two hearings. One was conducted in person, the other over the telephone. You will likely be scheduled for a telephone hearing. Your hearing notice will tell you if you are scheduled for a telephone hearing or an in-person hearing. You do have the right to appear before the examiner in person. If you would like an in-person hearing, contact the appeals section at the telephone number provided on the hearing notice. Requests for in-person hearings should be made immediately after being notified of the hearing. Requesting an in-person hearing could cause a significant delay to the hearing date. The hearings you have watched dealt with unemployment insurance claims. However, you may be scheduled for an administrative hearing regarding other issues, such as claim for unpaid wages, eligibility for training or schooling programs, or issues regarding taxation. The same basic procedures and concepts apply to those hearings. Now, let's recap the important points of this presentation. First of all, prepare. Think through your case. Make arrangements to have your witnesses and documents available for the hearing. Choose witnesses who have first-hand direct knowledge about your case. If you're an employer, do not bring the personnel manager because they fired the claimant. Bring the supervisor or other persons who saw or heard what happened to cause the firing. Often the personnel manager can only testify to what they were told by others. If you're a claimant, don't bring your spouse because they can tell the examiner that you are honest in telling the truth. Bring witnesses who have actual knowledge about your case. Remember, a witness who can be questioned will carry much more weight than a written statement. Remember to stick to the facts. Avoid emotions. Emotions often cloud the issue and prevent you from properly presenting your case. Organize your case in writing. By doing that, you'll be able to make sure that all important points are covered. Remember, this hearing will likely be your only opportunity to present your case. If you need a subpoena or an interpreter or have other special needs, immediately contact our office. Our address and phone number are on the hearing notice. If you pay attention to these few details, you should be as prepared as you possibly can be on the day of your hearing.